Hi friends, in earlier discussion we covered the Consumer Protection Mediation Rules 2020. Now we are discussing on regulations, mediation regulations 2020, which came into force from 24th July 2020. More procedural details are given under mediation regulations. These regulations uh, regulations were notified in Government of India official gazette on 24/7/2020, and these regulations were made by the central government in exercise of the powers conferred by section 103 of the Consumer Protection Act 2019, the National Consumer Dispute Redressal Commission, with the previous approval of the central government. So, National Consumer Commission framed with the previous approval of the central government. So, this particular regulation is very important to understand the comprehensive view, and already I have discussed the name and when it came into force. And as usual, regulation 2 contains definitions for those words which are used under the regulations 2020. And here some words are used. Act means Consumer Protection Act 2019. Consumer Commission means the commission, district commission, state commission, national commission established under the Consumer Protection Act 2019 under different sections. Other words used: mediation cell. Again, similarly, the mediation cell, party, rules, sections, the same words also used in the rules 2020. Similarly, here, the same meaning. The mediation cell is the consumer mediation cell established at state level, district level, and national level under section 74. And parties to the dispute, rules under the CPA 2019 Act, and any section under the CPA 2019 Act means Consumer Protection Act 2019. Settlement, yes, settlement arrived at in the course of mediation. So that is settlement through before uh, the case dispute may be referred from district commission, state commission, national commission, which were pending before them. That case can be referred to mediation, and settlement happened through voluntarily, through the help of mediator. That is called as settlement. And any other words used in these regulations, if the definition is not given here, then we have to take definitions from the act where it is mentioned. Act means again Consumer Protection Act 2019. So in these regulations talk about the eligibility for empanelment as a mediator. Earlier, chapter 5, then rules, we discussed other things. Now rest of the other details are coming out from these regulations. Who can become a mediator? Who is eligible to become a mediator under Consumer Protection Act? So that is discussed under regulation 3. Anybody cannot become a mediator. any person cannot become a mediator because Regulation 3 describes the list of categories are given. Only those people can apply to become a mediator before district commission, state commission, national commission. Following persons are eligible to be empaneled with mediation cell. They are retired judges of Supreme Court of India, retired judges of high courts, retired members of a consumer commission, maybe district, state or national, retired district and session judges, retired additional district and session judges, or other retired members of the higher judicial services of the state. Then retired judicial officers having experience of not less than 10 years, an advocate with a minimum experience of 10 years at bar, the mediator empaneled with the mediation cell of the Supreme Court of India, High Court, or a district court, a person having experience of at least 5 years in mediation or conciliation, experts or other professionals with at least 15 years of experience, or retired senior bureaucrat or retired executives. So these are the persons eligible to file an application before the commission to become a mediator. So this is the list. Now question comes, even though they are the judges of a Supreme Court, High Court, District Court, or members of the Consumer Commission, judicial officers, advocate with 10 years, mediators empaneled with mediation cell of the High Court or Supreme Court or District Court. Last two clauses are very, very important here. A person having experience at least 5 years in mediation or conciliation. Last one, experts or other professionals with at least 15 years experience, or retired senior bureaucrats or retired executives. So here, especially before the regular courts or mediation annexed to High Court, annexed to District Court or Supreme Court, only judicial persons, means advocate who are undergone the training and minimum years of practice, they are eligible. But here last two clauses allows others other than the judges, other than the advocates, who are involved in a mediation or conciliation, they can also become a mediators before the district commission. I'm giving you example. For example, doctor who is involved in a he who has undergone, doctors or chartered accountants or academician or insurance officer, banking officer, who have undergone 40 hours training programs with any recognized mediation institutes, who are handling the mediation cases after their training. By showing those documents, they can also become a mediator before the commission under the Consumer Protection Act. Commission, depending on the type of the disputes, they can refer the name of the mediator, nominate the mediator. For example, if it is a medical dispute, medical negligence dispute, then doctor is a better person. Technology, he knows the medical field, as well as he knows the mediation skills, he can handle it more effectively. Similarly, other sector also, bank manager can handle bank disputes. So like that, different sector people with the mediation training certificate skills, they can also handle mediation, act as a mediator before the commission. So that is the speciality of m- the mediation under the Consumer Protection Act. Next one, next regulation 4 discuss on disqualification for empanelment. Disqualification means who are not eligible, who are not qualified to become a mediator or to enter into panel of mediators before the commission. So they have given a list of persons who cannot be appointed as a mediator. So that is a disqualification for empanelment. So these, I mean, following persons shall be disqualified for being empaneled as a mediator, namely, one, a person who has been adjudged as an insolvent person cannot be. Then person against whom criminal charges involving moral turpitude are framed by criminal codes are pending. So that type of persons are disqualified. Then a person who has been convicted by criminal court for any offense involving moral turpitude. So if any person is convicted for a committing crime and convicted by the criminal court, then that person is disqualified. A person against whom disciplinary proceedings have been initiated by the appropriate disciplinary authority and are pending or having resulted in a punishment, so those persons are also disqualified. Clause 2 talks about a person who is or has been interested in or connected with the subject matter of the consumer dispute, or is related to or has been associated or connected in any manner, including in professional capacity, with any of the parties to the consumer disputes or any of their associates, affiliates, promoters, holding companies, subsidiaries companies, partners, directors, or employees shall be disqualified for being nominated as a mediator in that case. So earlier clause 1 talks about directly who are not qualified, who are not appointed as a mediators. So that list is given in clause 1 of regulation 4, and clause 2 talks about in general a person who is or has been interested in or connected with the subject matter of the consumer dispute. One or the other way, if they are connected to that dispute, then they are also disqualified for being nominated as a mediator. So this is very, very important. Before appointing any person as a, or at the first stage itself, commission should look into this particular regulation before empaneling or taking the name or adding the name of a person as a mediator. The commission has to look into this particular regulation. Regulation 5 talks about procedure for empanelment of mediator. Yes, the president and members of a district commission, state commission, national commission, They are the selection committee members. They have to select, scrutinize for this particular panel of mediators. So, first thing, what is the procedure? What is the procedure for empanelment of mediator? First thing, each consumer commission, here consumer commission means it may be district commission or state commission or national commission. Each consumer commission shall invite application from eligible persons for empanelment as mediators by publication of notice in at least one English and one vernacular newspaper widely circulated in its jurisdiction. So they have to advertise. They have to, it's nothing but advertisement, or you can say publication of notice to the public that commission is invited application from eligible persons for empanelment as a mediator. So maybe one for, if it is in Karnataka, in a district commission, and they can publish that particular notice in one in Kannada language and one in English language newspapers, and also they can circulate uh, among all the district commission or state commission, and also they can put up that particular notice on their website. That is the first stage, invite application. So in that application they have to mention who are eligible, who are disqualified. They have to expressly mention that, so that whosoever applying, they should check themselves, are they eligible or not, are they disqualified or not. After checking that, they will apply. So that has to be disclosed. Everybody may not read the Consumer Protection Act rules, regulations. So that's why that information should be clearly mentioned. Second clause talk about the applications received by the mediation cell for empanelment as a mediator shall be scrutinized, and the list of eligible applications shall be placed before the selection committee constituted under subsection 1 of section 75. That clause, that subsection of section 75 talks about ultimately the selection committee is president and member, and the applicant applications has to be scrutinized. They have to check that application, that what they have filled, is there any disqualification is there or not, have they undergone any training program, 40 hours training program or not, and what is their where they are residing, all identity information. So all those things they have to check it. And if they say that they are eligible, under which category they are eligible, that has to be cross checked, then bring it before the selection committee. Then selection committee shall determine its procedure for making its recommendation. So on the basis of the applicant's credentials, background, they will check they are eligible or not. Then they will decide. So they will decide, determine its procedure for making its recommendation, and after taking into account the suitability, integrity, as well as relevant experience of the candidates, recommend a panel to be maintained by mediation cell. So they will finalize the list of persons who can act as a mediators, and that has to be maintained by mediation cell. And uh, those persons who are listed, those persons will be nominated depending on their expertise. They refer it to that type of dispute. Clause 4 talk about panel of mediators shall consist of not more than such a number of persons in the mediation cells attached to consumer commission as may be decided by the president of the Consumer Commission. So it depends on the commission, president of the Consumer Commission. On that basis, that number of persons may be listed. The consent of the persons whose names are included in the panel shall be obtained before empanelling them. The mediation cell shall be headed by the president of the Consumer Commission. So, the gist of this particular clause 5, what it says: invite the application, give publicity of invitation of the application to become a mediator. Then they will scrutinize depending on the eligibility, experience. They make a list, put it before the selection committee. Selection committee is president and members. They will decide the procedure, how best people can be selected as mediators, and how many number of mediators can be listed. That has to be decided by the president of the commission. And once they selected as a mediators, commission should send a communication to the concerned person saying that you are selected as a mediator in panel of mediators, so kindly give your consent in written form. So then that person whose name is listed, if he is interested, then he gives consent. Usually interested people only applies, but it's a formality that at that moment that particular person who is selected, he has to give consent. It's a procedure. And mediation cell shall be headed by the president of Consumer Commission. So here the president of the Consumer Commission, before him dispute comes, he knows the nature of the dispute, he knows who are in the panel of mediators. So depending on their expertise, mediator will nominate a person, mediator, from that list to that particular dispute. And the president of the Consumer Commission is heading the mediation cell. Even though once it is referred to the mediation, president he will not involve in the mediation procedure. Only he can supervise. But as a under the regulations, he is head of the mediation cell. So this is discussed under this particular rule. Regulation. Regulation 6 talk about removal of mediator. So at the beginning itself, we discussed mediator is should be a trustworthy. He is a neutral party. He has to facilitate the people and who are involved in the dispute to settle the matter amicably. So that is the major or characteristics of the mediator. So this particular regulation 6 talk about if a mediator is discovered to be disqualified, or he in any manner misconducts himself as a mediator, or he is otherwise found unsuitable to continue as a mediator, the mediation cell may remove his name from the panel of mediators after giving an opportunity of hearing to him. So again, if anybody files a complaint against the mediator, again maybe misconduct or anything which is unsuitable to continue as a mediator, then mediation cell may remove his name from the panel of the mediators after giving an opportunity of hearing. So always natural justice principles should be followed. before removing, give opportunity, and if he explains, if he clarifies, and if you are satisfied, let him continue. If you are not satisfied, remove him from the panel. So that power is with the president of the commission. Then regulation 7 talks about re-empanelment of mediator. So only such mediator shall be eligible for re-empanelment who, in the opinion of the mediation cell, have successfully and efficiently discharged their functions as empaneled mediators, and such re-empanelment is made on the basis of the recommendation of the selection committee. So what regulation 7 talks about re-empanelment. So already they are empaneled and they are doing well, successfully, efficiently discharge their functions as empaneled mediators, and after the particular period is over, then commission can re-empanelment their name again continued or added in the panel for another period, because their past experience, their past performance was good, and those successful or if effective people, efficient people should continue further in future also, and the term can be given to them. Regulation 8 talks about fee of mediators. So mediators who involve themselves to settle the matter amicably by providing facility, by using the facilitative method, so for their effort, for their work, that has to be respected by giving the fees which is fixed by the commission. So a consolidated fee in a successful mediation shall be paid to the mediator who conducts the mediation proceedings from the time of reference till their conclusion. The fee of the mediator empaneled with the Consumer Commission, including the costs of secretarial assistance and other ancillary expenses, shall be fixed by the President of the respective Consumer Commission, case wise, considering the nature of the dispute. So the fees is fixed by the President. In an unsuccessful mediation, half of the aforesaid fee will be paid to the mediator. For successful mediation, the full fees is paid. If it is unsuccessful mediation, then whatever amount is fixed, half of that fees will be paid to the mediator. The fee of the mediator shall be shared equally by the two sets of the parties. The fees of the mediator shall be shared equally by the two sets of parties. Two sets of the parties, one is a complainant, another is the opposite party. Assume that fees is fixed by the commission is 10,000 rupees as a mediator fees. Then if it is settled through mediation amicably, then both parties, complainant as well as the opposite party, has to share equally that 10,000. It means each of the parties have to pay 5,000 rupees each to the mediator. If the mediation is failed, unsuccessful, then if 10,000 fees is fixed, then 50% of that is 5,000. That 5,000 has to be shared equally by both the parties in case of unsuccessful mediation. Then clause 5 talks about the mediator who successfully conducts part of the proceedings will be paid such fees as may be fixed by the president of the Consumer Commission. The mediator who successfully conducts part of the proceedings will be paid such a fees as may be fixed by the president of the commission. Clause 6 talks about the fee shall be deposited in advance with the mediation cell. Assume that today commission nominated one person as a mediator whose name is in the list for a particular dispute, and at that time only commission will fix the mediation fees, and that fee shall be deposited in advance with the mediation cell. If a party does not deposit his share of the fee or the cost of mediation, the Consumer Commission may, on the application of the mediator or any other party, direct the party in default to deposit the same within a week. So it means in advance they have to deposit. If they have any party is not deposited their share, then the commission may, on the application of the mediator or any other party, the commission may direct the the party who has not deposited, directing him or her to deposit that particular amount within a week. Even after direction of the commission, he fails to deposit such fees or cost, the Consumer Commission may permit the other party to deposit the same and recover the said amount from the party in default in the manner prescribed for the execution of a money decree by a civil court. No other party deposited the share of the party in default, the Consumer Commission may terminate the mediation proceedings. It means if both parties have not deposited their share to the mediation cell after the commission given the direction to deposit that amount, even after direction, if both parties are not depositing, then commission may terminate the mediation proceedings and it will come back to the commission, and it will continue as per the Consumer Protection Act 2019. Earlier clause what talks, it said if one party paid his share, other party not paid, and even after direction not paid the amount. During that time, one party who has already paid, that party can deposit other party's share also to the commission, and mediation will continue, and whatever amount paid, fees paid of other party, that amount can be recovered later as if it's a money decree by civil court, so that amount will comes back. So that is the gist of this particular regulation. Regulation 9 talks about training. I told you that any person cannot become a mediator, whosoever may be, because mediation is a skill. He has to understand the nature of the dispute, he has to understand mindsets of the disputing parties, he should understand how to handle the parties, how to bring them calm, how to bring them on track, how to neutralize their bias, and how to settle amicably. So that is a skill. So hence the training is mandatory. If anybody join in the panel list who have not undergone mediation training, then they should undergo mediation training. Then only commission will provide or nominate their name for a as a mediator for a particular dispute. If they have not undergone any mediation training program, then commission should not refer their names to any disputes as a mediator. Otherwise, the trust in a mediation process itself will frustrate. Public will not get a faith trust on mediation procedure. That's why commission should handle it very sensibly and effectively. So regulation 9 talks about the training. The mediator shall be given appropriate training in conducting mediation by such experts as may be nominated by the mediation cell, and it shall be obligatory for them to attend such training. So they should attend that training, because they will get the benefit, they will get the skills, they will easily handle the parties of the dispute, and amicably they can capable of settling the matter. Regulation 10 talk about code of conduct. So once the mediator person's name is entered in a list of mediators, then they have a duty, a responsibility towards the public, towards the parties, towards the commission. The impaneled mediator shall not communicate directly or indirectly with any of the parties or their associates, affiliates, promoters, holding companies, subsidiary companies, directors, partners, or employees, or with any of the counsel during pendency of the mediation proceedings, except during the course of mediation in the presence of the parties of or their counsel. The impaneled mediator shall not accept any gift or hospitality from any of the parties or their associates, affiliates, promoters, holders, companies, subsidiary companies, directors, partners, or employees, or any of their counsel. Why this type of rules, code of conduct? Because the mediation itself is a voluntary process, means both parties to the dispute voluntarily they have to come forward to settle the matter through mediation, and they have to trust the mediation procedure, they have to trust the mediator, they will give justice, they will usually we say mediation is a win-win position. Both parties to the dispute, they are settling the matter amicably, and both parties are happy, and there is no enmity once the case is the dispute is settled through mediation. So that's why these ethics of the mediation should be followed. Code of conduct is nothing but a ethics of the mediator should follow during handling that particular dispute as a mediator. So he should not involve, mingle with any of the parties and connected with the parties during the pendency of the mediation proceedings. Yes, they can meet separately, jointly, when during the course of mediation, not otherwise. And also, any of the parties wants to give the mediator any gift or hospitality, not only parties directly or indirected people, so mediator should not accept that particular gift. If one party gives a gift, if it is known to the other party, then other party will not get a trust on that mediator. Because he has taken a gift, he may favor the one who has given the gift. So that type of suspect should not come. So that's why these code of conduct is mentioned. Other provisions, other things in addition to the whatever above the under clauses A and B of section 77, each mediator shall disclose the following information before commencement of the mediation in the case of assigned to him. So when the commission refer a particular person whose name is in the list as a mediator, then once he become a mediator to a particular dispute, when he comes to know that parties to the dispute and what type of case it is, what are the issues involved, then before starting the mediation process, he should disclose some of the information which are listed here. So he has to disclose to the parties and to the commission whether he has or in the past had any personal, business or professional relationship or connection with any of the parties to the consumer dispute or other proceedings, or any person associated or connected in any manner to any of the parties or their associates, affiliates, parent company, subsidiary companies, directors, partners, or employees. So he has to disclose any connection to those of the parties, companies, and related in past, whatever connections are there, he has to disclose. Whether there exist any circumstances which may give rise to be reasonable doubt as to his independency and impartiality. So any other circumstances which, by knowing that particular thing, any of the parties may doubt about the mediator's independency, impartiality. So if that type of circumstance facts is there, then he has to disclose at the beginning itself. So why all these information should be disclosed? Because ultimately mediator has to show to the parties, disputing parties, that he is impartial, he is independent, and parties can trust the mediator. Once they get a trust, then only they can move freely, they can share the hidden facts to the mediator in a caucus session, in a separate session. Then this will help the mediator to settle the matter quickly. Regulation 11 talk about mediation proceedings. So once the case is referred to the mediator, mediation shall be conducted in the presence of the parties or their authorized representatives or counsel. Then the mediation shall stand terminated on expiry of 3 months from the date of first appearance before the mediator, unless the time for completion of the mediation is extended by the Consumer Commission, in which case it shall stand terminated on expiry of such extended time. So this clause expressly mentioned that once the case dispute is referred for mediation and both parties appeared before the mediator, from that date 3 months is the time available for the mediator to settle the matter within that particular period. If it is not completed, and if it is probably it can be settled by maybe within a week or 10 days, then the mediator has to request with the consent of the parties to the commission, and commission may extend to that extent. Once that extension is given and that extension is completed, then it is considered as a the mediation is terminated. Within that period, if it is settled, then settlement happens and decrees is passed on that. So if extension is not given, then automatically that mediation will terminate, expire after 3 months from the date of first appearance before the mediator. The party shall be entitled to appear before the mediator in person or through their respective counsel or authorized representatives. So it's not mandatory that party in person only should appear before the mediator, but it is encouraged, especially under Consumer Protection Act. Always the intent of the legislator is to party in person should come and try to settle the matter, because it is a very simple procedure, and especially through mediation. In mediation, the mediator can discuss more effectively with the party and try to settle the matter amicably. And if party is not if he wants to appear through his respective counsel or authorized representative, it can be allowed. So no bar on that. So mediator can entertain depending on the wish of the party. The mediator shall be guided by the principles of natural justice and fair play, and shall not be bound by the provisions of Civil Procedure Code of Civil Procedure 1908 or the Indian Evidence Act 1872. If mediator follows CPC or Indian Evidence Act, it also becomes another civil code, because they have to follow strictly those rules. Automatically it takes more time. That's why it is mentioned that mediator should follow natural justice principles and fair play, through which it can be settled quickly. Then if a party does not participate in the mediation proceedings, the Consumer Commission may direct such party to participate in the proceedings. So if any of the party is not participating, then mediator has to inform to the Consumer Commission, and Consumer Commission may direct that party to participate in the proceedings. The parties shall provide all such information to the mediator as may be reasonably required by him for conducting the mediation proceedings. So both parties, or whosoever parties are to that particular dispute, should provide all the information, and then only it is possible for the mediator to understand the seriousness of the parties, and also it helps the mediator to identify the issues between the parties, and he will try to settle that matter amicably. So it helps the mediator to understand the position and interest of the parties, and then he will handle it more effectively. For that purpose, the party should cooperate with the mediator. Then the record of the proceedings shall be prepared by the mediator on every date and shall be signed by the parties or their counsel or authorized representatives or attorney. So whatever happens during the proceedings, it should be recorded, and whatever both parties have mentioned, that has to be put it in written form, and both parties have to sign, and even mediator will sign in place of parties if advocate has come or any authorized representative have come, so they can sign it. Ultimately, what it's a proof for what they have discussed and what they have approved or consented. Then the agreement executed between the parties shall be submitted by the mediator to the Consumer Commission in a sealed cover with a forwarding letter. What we have discussed earlier, both parties appeared before the mediator, and mediator with natural justice principles discussed with the both the parties separately or jointly. Ultimately, we are discussing on regulation 11 mediation procedure, and clause 7 talks about record of the proceedings shall be prepared by the mediator on day to day whatever discussion happens, and it should be signed by the parties or their representatives. And once the agreement is executed, successful settlement agreement is executed, then both parties have to sign on it, and mediator has to sign, and this agreement may not contain all the details whatever they have discussed in past 3 months. It is only operative portion of the dispute or the settlement. Rest of the things whatever proceedings they have recorded or they kept it in paper, so that is not needed to enter into this agreement, and this agreement contains only operative portion. That's why it is called, it will be more confidential. So whatever, on what basis you come to conclusion, what was the discussion, so there is no need. But if it is happened in the regular court, every day whatever you have discussed, that will be in public domain. But here, last 3 months whatever you have discussed is not known to anybody, only those parties, and mediator knows it, not third person. And that agreement has to be submitted by the mediator to the Consumer Commission in a sealed cover with the forward letter. Then clause 9 talk about if no agreement is executed between the parties within the time prescribed in these regulations, the mediator shall intimate so to the Consumer Commission without in any manner disclosing as to what transpired during the mediation proceedings, what was the stand taken by the parties, or why the agreement could not be reached. Clause 8 talks about successful completion or successful amicable settlement agreement, and clause 9, if it is not done, if it is failure to settle the matter through mediation, it means no agreement is executed within that particular time as prescribed by the regulations, then mediator shall inform to the Consumer Commission without mentioning, disclosing what has happened during that 3 months, why it was not settled, what was the stand of the parties. So all those things not mentioned in the that particular report or that particular letter. So that is the duty of the responsibility of the mediator. So that is the procedure. Now we are discussing in rule 12 role of mediator. So how mediator should behave, how he should act. So that is discussed in regulation 12. The mediator shall attempt to facilitate a voluntary resolution of the disputes between the parties, assist them in removing the misunderstandings, if any, and generating options to resolve their disputes, but shall not impose any term or any settlement upon the parties. The mediator shall explain the terms of the agreement to the parties before obtaining their respective signature on it. So, Regulation 12 talks about the role of the mediator, how he should act, behave during the mediation proceedings. So, he has to facilitate both the parties, understand pros and cons, understand them separately or jointly, joint sessions, assist them in removing the misunderstandings. Always dispute starts because of misunderstanding between the parties, and they are not ready to come forward one to one, discuss and clarify the confusion. That's why dispute starts. So here in mediation proceedings, through mediator, he is trying to remove that misunderstanding between the parties. Once that misunderstanding goes out, then automatically both parties are ready to settle the matter. And also mediator can generating options to resolve their disputes, but shall not impose any term or any settlement upon the parties. Ultimately it's a voluntary process. He can give options, but ultimately it is a wish of the parties. Voluntarily they should accept and sign the agreement. The mediator shall explain the terms of agreement once they are agreed for the settlement, and mediator written as per parties wish on a paper, and once he has written the terms and terms of the agreement, he has to read and explain both the parties as per your wish. These are the terms of agreement. If any confusion is there, any clarification, they let them ask and you clarify. Then the mediator has to take their signature on that agreement. Regulation 13 talks about confidentiality. It is again one of the characteristics of the mediator. The parties and the mediator shall maintain confidentiality in respect of the events that transpired during the mediation proceedings, and shall not use or rely upon any information, document, etc. produced, the proposals and admissions made or the views expressed during the mediation proceedings. There shall be no audio or video recording of the mediation proceedings. So here confidentiality not only on mediator, even parties, whatever happens during the mediation proceedings, it should kept confidential. Whatever happens, whatever documents are shared, so all those informations should kept confidential. It should not be shared anywhere with anybody. So that cannot be shared. That has to be kept secret. That has to be a confidential. And during the proceedings, no person, no parties or mediator should record audio recording or video recording. It is completely prohibited. Then Regulation 14 talks about communications. The mediator shall not communicate with the Consumer Commission except by way of his report with copies to all the parties. Once the mediation is referred to a mediator, once the dispute is referred to the mediator, whatever happens during the mediation proceedings, that cannot be shared with even consumer commission until it completes. Until it completes. Once it completes, success or failure, that has to be communicated through mediator's report, written report, and whatever he is submitting the report to the consumer commission, that report has to be shared with the all the parties to that dispute. Nothing is secret, everything is transparent between or among the parties, consumer commission and the mediator. So that is the procedure. Regulation 15 talks about immunity. No mediator shall be liable for any civil or criminal proceedings for any act done or omitted to be done bona fide by him in his capacity as a mediator. The mediator shall not be summoned by a party to appear in a court or other forum to testify in regard to any information received or the action taken by him during the mediation proceedings. Here, one who is involved in a mediation proceedings as a mediator on the direction of the consumer commission, that person is not held liable for any of the civil or criminal proceedings. Whatever he has done during that mediation proceedings. And also, that mediator should not be summoned by a party to appear in a court or any other forum. So to testify in regard to any information received or the action taken by him during the mediation proceedings. So this immunity is given to the mediator. So that's why mediator, without any hesitation, openly, he can discuss, he can deliver, or he can try to settle the matter during the mediation proceedings. So this immunity is given. In one of the judgment also, High Court clearly mentioned the mediator cannot be summoned to testify in any of the cases. Regulation 16 talks about reports. So every mediation cell is handling the mediation proceedings. They are referring, mediators are referred to particular dispute. Their timeline within 3 months has to be disposed of. Extension is given or not. Parties are attending or not. Settlement is done or not. Is it a failure or not? So all the data the mediation cell should maintain. So every mediation cell shall submit a quarterly report to the district commission, the state commission, and or to national commission to which it is attached, containing the following information, namely. So they have to give a report, and that report contains list of its empaneled mediators, including experience and qualifications of each of them, number of cases pending before it at the beginning of the quarter, the number of cases referred to it during the quarter, number of cases disposed of during the quarter, the number of cases pending at the end of the quarter. All these information should be mentioned in quarterly report by the mediation cell, which is attached to the district commission or state commission or national commission. Other information has to be mentioned in the report are the number of cases assigned to each mediator, the number of cases disposed of by him during that quarter, and number of cases in which the mediation referred to him was successful. Then the number of cases in which mediation was not successful, the fees paid to each mediator during the quarter. Then the report shall be submitted within 1 month of the end of the each quarter. So this information, this report has to be submitted by mediation cell to the commission, so that commission will come to know the success of the mediation, or is there any need of improvement facility wise, or they come to know which mediator is handling the disputes more effectively, more successfully. So all those information the consumer commission will get through this mediation report, which should be submitted by the mediation cell quarterly. So this is about the regulations. So we looked into the some sections of the Consumer Protection Act, which mentions that Consumer Commission can refer dispute to the mediation, and if it is failed, then same procedure will continue, and if it is settled, no appeal is against the mediation settlement. And then we discussed the chapter 5, all the sections. Then we discussed mediation rules, and lastly we discussed mediation regulations. So now at the end of this particular session, I hope you understood comprehensive view of mediation under Consumer Protection Act 2019. Especially for this particular mediation chapter or rules regulations, central government has done a lot of work, especially Consumer Ministry, to make it successful, because nowadays parties or people are very busy. They are not having a time to come continuously for longer period to get the justice before the Consumer Commission. Now through mediation outside the commission, they can settle the matter. Now, as I mentioned, the the Ministry of Consumer Affairs encouraging settlement of disputes through online, and even now under the new Consumer Protection Act 2019, you can file a complaint online. All digital mode is recognized, and looking into the change in the business, change in the market, change after COVID, lot of things are changed. So online is recognized. In future we may come across these mediation proceedings may happen online, which is comfortable for the parties as well as the mediator, as well as the mediation cell and the Consumer Commission. And even if private mediation centers are there, then those centers, reputed mediation centers, can be recognized by the Consumer Commissions, and then those the institutions infrastructure, physical as well as virtual infrastructure, can be used to settle the matters through mediation. And in future we may get, or we may hope, the more number of disputes settled through mediation, that is also online mediation. So that is the hope in future. and it's a good opportunity for the business, especially opposite party is a business, is a company. If they settle the matter amicably through mediation proceedings, then they can protect the secrecy, uh, the through confidentiality. It will not be disclosed to the public, so that through that way they can protect the reputation of the company, because ultimately if it this case goes to the uh, court, and through regular proceedings, if it is settled, all the documents of the consumer commission open to the public, and reputation of the company will come down if every public reads it, and even newspaper they publish it, and through that way a reputation of the company is under risk. So this is a better way to settle the matter through mediation. So with this uh, I conclude mediation under the Consumer Protection Act 2019. It's a very good opportunity, and everybody must use it. And even Consumer Commission members should understand the importance of the mediation, and always they should try to convince the parties the merits of mediation, and try to refer those cases, uh, depending on the rules and regulations, to the mediation proceedings. And also they should select those trustable integrated people should be the mediator, and who have undergone 40 hours training program from the reputed institutions. Those should be appointed as a mediator to build trustable uh, mediation in India. So that is the way how we should go ahead. Thank you.